All right, first item on the agenda is a preliminary review.
Well, you can call them separately, we can argue, or we can call them together, since they're essentially the same person.
Okay, all right, the first is 2021G-018, Hicks versus Committee to Elect Alan Freeman et al. So, see what we have.
I think I go first. I think
No, I'm
that's
just
pending
saying.
motion that,
Yeah, Mr. Bryan would go first because it's his motion that we're here to address, which is the motion to continue. You all have my recommendation, which is to grant the respective motions in both cases.
I've never received this motion.
I served you.
No, not that I'm having any recollection of.
I didn't serve, but I know he sent a copy to me.
No, I've never gotten.
I don't
So
know.
I
why
object to
you
the
did.
motion being heard because I've never been served a motion.
I believe I served him. You know, if we need to continue this so we can serve him and argue, that's fine, but I believe I did serve him.
I didn't.
And if he says he didn't receive it, sometimes that happens in email. I don't know what to tell you.
If I had known there was even going to be a thing, I would have been not wanting to make a trip to Columbus because, but I never was aware that there was a motion going to be considered at all. Nor do I believe I was ever served a motion.
Do you have like on your email or anything?
I can probably track that, yeah, I don't have it with me, but that's ordinary course. We serve copies of everything.
Can I get a copy of whatever motion you're talking about right now?
Yeah.
So I'd just like to know, I'd have to look to see if I was served, but this is from April,
Right.
and nobody ever schedules any motion hearing, so, nor has it ever been brought to my attention, so I don't know that I was served this or not, but I'd have to go check more since it's so old. But also, I received no notice that this motion was going to be considered or argued.
I do want to note that Mr. Caraway has recused himself and stepped out as out of the meeting. So,
I can't. I assumed he had it. I assumed everybody knew what today was they talking about. As much as I would like to go forward and argue the motion to continue today, if Mr. Hicks says he did not receive it, I don't think it would be just to require him to respond to a motion we know he's going to argue for. Because I've been in that situation. I'm not going to make a different argument when it's somebody else's office before.
But the fact that that achieves the same purpose, so I think that's self-serving. I'd like there to be a preliminary hearing, because by saying continue, it's either way, it's making there be a continue.
Yeah, all of a sudden, with the joy of the state system, my emails, I'm not transferring my state email system. Because I was going to double check,
Mr. Richter
but I
is
can't because
checking.
I'm disconnected from the state email system. Oh, I don't know.
My understanding was, and I'm not trying to prejudice Mr. Hicks's right to know what we're talking about, if in fact he doesn't know. And I thought I served him, but he said we didn't receive it, and who knows? Yeah, but we've had experiences with that before in these cases. My understanding is that today was being an argument about the motion to continue. And I was advised by Phil Richter not to file a substantive response to the case under merit until that motion had been considered. And if it were denied, then obviously a preliminary review would be scheduled presumably shortly. If not, there would be a wait until the appeals on the original case were resolved. The idea being that this case 2121G-018 and case 2022G-014 our Hicks v. Freeman campaign. The case that's on appeal was 2020G-018, is still on appeal. It was also Hicks v. Freeman campaign. Every single one of them dealt with the 2020 primary, every single one of them dealt with the...
I want to object to this. He's effectively arguing his motion
Well,
right
I
now.
would say that we really need to hold our comments until, I believe Mr. Hicks.
Okay.
I'd also like to object the fact that clearly there's ex parte conversations that are happening with the director on what motions are going to be heard and when that I'm not even told about or a party to, which I think is inappropriate, and it's got to stop in this commission, that there's special treatment for certain lawyers that other people don't receive. All conversations with him by either one of us should include us all, so that we know what's going on, and there shouldn't be, and if we are going to have motion hearings, as what happened in 2020, I think it was 2021G-019, those should be on the agenda. Previously, motion hearings were on the agenda with what motions were going to be heard. That seems to have slipped away also.
Since Mr. Hicks has raised the point, I do not, about ex parte communications, I would respond by saying that my understanding has always been that the executive director serves a function like the bailiff of a judge. You cannot ex parte a judge, but you can talk to the bailiff. And the bailiff will filter things so that the judge, in this case the commissioners themselves, are not improperly influenced. But there is improper influence, I would suggest, if Mr. Hicks, as he has repeatedly done, communicates directly with the members of this commission themselves. As a lawyer, I can't do that without following the ethical provisions. And Mr. Hicks, notwithstanding being instructed not to do so, has continued to do so. And that prejudices people who aren't for it. So if we get to the merits, we can talk about that I raise it now only because Mr. Hicks raised that issue, which really isn't before us right today.
Well, what I'm seeing in my emails is I got these motions from Mr. Bride, and there is not a to or
No,
a
I
CC.
did a separate email to Mr. Hicks, is my recollection.
Oh, okay, I was gonna say, in the email to me, he is not either listed or a CC. I did broach the subject of continuing these matters at a July 20 meeting that didn't work schedule-wise for one or both of you, I can't remember which. And so then I set the matter for today. So that's the contact that I've had as it relates here. So,
Madam Chair, if the communication was by email, Mr. Hicks appears to have a computer, could you search and see if he has received it?
It was probably by email, sometimes I did by mail. Actually, this one was by mail, but I can verify that. And the reason I know that is because I never talked to my secretary, make sure you mail it to him. And she might have emailed it to him, but I'll have to check when I get back to the office.
Would you be willing to look at some of the emails?
No, because notwithstanding if there's going to be certain motions argued, I should be on notice that they're going to be argued. As anybody knows that's been involved in court, there can be all kind of motions get filed, and a lot of them never get argued. They just sit there because the judge never brings them forward. But so if there's going to be a motion argued, I should know. Obviously, he knew. He had communication with the executive director on the substance of the case. My communications have always been about procedure, not substance of cases. So, why don't I make it easier though? I'm okay with arguing these.
If he's okay with arguing these today, I'm okay with arguing these today.
But I want my objection to be noted that this commission has got to get to the point where the rules are followed the same for everybody, and people are on notice of what's going to be argued. Because it sounds like effectively we're going to get to the same solution whether we argue them or not today, is that somebody's going to want to continue this because it's kind of a catch-22. So that's why I'm saying we can argue them, and if the outcome is we continue or not continue, it sounds like if we don't argue them, we're effectively gonna end up at a continuance of some sort anyway. So given that, I'm okay with arguing them, but I think we've got to, this commission needs to tighten up its procedure. And I'd like to argue them separately.
That's what the plan is.
Yeah, if they're, the parties are amenable.
Madam Chairman, may I argue the merits of the motion?
Which one?
Well, they're both the same. My
No, I want to
argument-
argue them separately.
You can argue them separately. I can present my argument as I like, and I would appreciate you not interrupting me with argument.
They are two separate motions
Mr. Hicks.
on two different
Mr. Hicks.
cases.
Mr.
Yeah, I want
Hicks.
them to be argued separately.
Then you
That's
can
my
argue
right
separately.
in due process.
We oftentimes will consolidate arguments. If you want to argue them separately, that's your choice, but essentially the argument, the essential arguments are the same across the two cases.
That's not correct, Phil. That's why I want to argue them separately.
I
because they're two
believe-
different
Let's,
I
cases.
have
let's
the
take them one
floor.
at a time.
And I would appreciate it if Mr. Hicks would keep his comments to his time at the podium.
Okay, so we're gonna be respectful of one another, and we're gonna take the first case, 2021G-018, and argue it, and then we will go on to the next case, which is 2022G-014. The first case is 2021G-018, Mr. Brown.
Thank you. As I said before, as I tried to say, both cases are basically dealing, well, both cases are Hicks versus Alan Freeman. So you've got Hicks v. Alan Freeman in 2020G-019, the case is still on appeal. You've got Hicks v. the Freeman campaign in 2021G-018, which is the first case on the list today. And you got Hicks versus Alan Freeman in the 2022G-014 case. Every single one of them, it deals with the 2020 primary election. Every single one of them deals with the quarter contributions and expenditures of the 2020 primary election. And even Mr. Hicks admits in what he filed this morning, I didn't read it all, but I read the first page of his 171-page submission a couple hours ago, in which he acknowledges that these are all Freeman-related cases. That's his phraseology. And he goes through, say, to understand the cases we're hearing about today, and he was dealing with both of them, and we filed a 171-page thing this morning. You need to know the background of the 2020G-019 case. I assume that's why he had this 171-page missive that I didn't read it all. I suppose you didn't either. But even he acknowledges these cases are all related. And for that reason, a continuance is proper because it avoids duplication. There's some issues, legal issues primarily, but they're being presented in front of the Franklin County Court of Appeals. It's all been briefed and argued. They can issue their decision where they want to. After that, there may or may not be an attempt by one side or the other to appeal to the Supreme Court, which in fairly short order, they're going to say yes or no. You know, and obviously that they don't have to take jurisdiction over an appeal, but they might depend upon how it's presented, whether they think it's appropriate. It could resolve, the appeals could resolve disputed issues. What's the scope of authority of this commission in cases dealing with these factual scenarios, this type of evidence, these types of facts, these types of allegations? They'll deal with issues about notice requirements. It was sort of interesting, Mr. Hicks was talking legitimately in some respect about notice requirements as a party. We have the same right of notice requirements as a party. We're arguing about that in the Court of Appeals. To the extent that there's an issue about that something gets beyond the scope of what one party thinks is appropriate, well, the Court of Appeals may help resolve that. It also presents the requirement that we present hypothetical issues. In other words, there are a number of legal issues that we would necessarily have to present before a preliminary review that may or may not still be viable issues to present once the Court of Appeals resolves the disputed matters in front of it. And generally it's a matter of economy, judicial economy, as well as the economy of administrative bodies. You decide real disputes rather than disputes that if come. In other words, we would be in a position of saying, if they rule this way on the scope of the original hearing, this is our argument. But if they rule that way, this is our argument. not a very effective way to have a clear and understood argument about what the commission can and cannot do. And, you know, in that respect, the communications that the commission has made through its counsel on the matters on appeal, to some of them, it takes a different position about the scope of its authority than Mr. Hicks has made in some of his filings in this case and in the related cases. Presumably, even from Mr. Hicks' point of view, if the Court of Appeals goes his way, CCI was right all along, and if they go in the other way, he's not going to do that, you know, in terms of that. You know, yeah. And lastly, Phil Richter has recommended granting this motion, both of them, but we're arguing over 18 right now, for all these reasons. This is basically the same case, with some additional facts and additional permutations. I'm sure Mr. Hicks is going to stand there and say, no, it's way different. But the reality is, we're arguing once more about the report of the 2020 primary election campaign finance stuff. And frankly, Mr. Freeman can't know what he needs to fix or how he needs to fix this. Maybe even after the Court of Appeals and the Supreme Court, if they get that far, he said. But certainly beforehand, because right now, he's in a state of limbo about what do I do and how do I do it. Mr. Hicks thinks it's clear, but he also thinks, because he said so, that the Court of Appeals should reject our appeal. So, you know, they might not. And if they do, one thing happens. If they don't, something else happens. In either case, it changes dramatically the lay of the land in terms of evaluating the second and third Hicks v. Freeman complaints that Mr. Hicks has filed. And for all these reasons, I recommend that Phil Richter's recommendation to continue this case and the other one be granted.
Madam Chair, can I ask a question in general? Is the camcorder that is set up across the room on?
Yes.
Do we have to allow that? I don't really particularly appreciate that it's staring right at Ms. Hagan.
Actually, you do need to allow that. That's the Ohio Open Meetings Act.
We have the thing on
It
camera.
doesn't matter.
Oh,
We have generally allowed persons to video commission meetings over the history of the commission. And I think it's policy-wise, I think it's a good decision to make. I appreciate your concerns, but it is an open
Can I
meeting.
request it not be staring right at my face and have a more broader view of the room?
I assure you, it's only seeing the whole room this way. But I also want to be clear, because Mr. Ricker is not clear, it is absolutely a requirement of the Open Meetings Act that you allow citizens to video or audio record any meeting subject to the Open Meetings Act. The only thing you can do, if you want to do it in the future, is you could designate a specific area for camera equipment to be put in. You can also, for example, prohibit camera equipment that was overly loud or disruptive to the meeting or something like that. But you don't have an option whether to let somebody do it or not, or to say, we're already recording it, so you can't record it.
Fair enough.
You can't set up, you know, and I've been in places where they might, like, if they get really serious about it, they'll mark on the floor, this is where the cameras can go, so that there's no question. But I assure you, it's not aimed at you.
It looks like it is.
No, it's
Like I'm
sticking out
staring
the hall,
straight
it's as
at
wide
it.
as it can go, it's as wide as it can go.
In the future, I would prefer that we designate an area that, I don't know, feels less intrusive. But I appreciate the comments, I do.
If I may just say, he's not a lawyer, but he's right. I mean, I don't do that because I think it would irritate you, but he's right that there is a right.
Can I proceed with mine?
Okay. Mr. Hicks needs sworn in.
Raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
So my first hint that there was going to be any attempt at something happening odd here was that the agenda that is not given to the public, but that is given to you, that tells you how you're supposed to vote on matters before you, which I think the public would be shocked to realize you get an agenda that tells you how you're supposed to vote, said on it, recommendation, grant the respondent's request, that doesn't even say motions, in the respective cases to continue the matters pending the resolution of the appeal, the previous case involving Alan Freeman. I just want to point out that I got a copy of this agenda that you got from Mr. Ricker when I asked him. He got one because when Mr. Ricker walked in the room, he gave him a copy of your version of the agenda. This is where we gotta, I think you guys need to clean stuff up here before this commission. As it relates to these motions that I didn't know were gonna be argued today, I wanna just remind everybody, the executive director controls the scheduling. The executive director controls the scheduling. He put on the schedule preliminary reviews for these matters for this hearing. If he had any question, he could have just not put it on the agenda. He controls what's on the agenda. So I find putting it on the agenda when I have to drive, I know a lot of you had trouble getting here today because of the rain, but remember, Chairman Kreitz probably four times, directed Mr. Richter to put in place the ability for people who are not on the commission to be able to testify remotely so that they didn't always have to travel, because back during COVID, you had much more participation. So I feel like I've been duped into coming here under false pretenses, without being informed that there was a motion that I recall any information on, or that that was what was going to be argued here, versus that we were actually going to have preliminary hearings on these matters. So he controls the scheduling. Also, I'm not sure, do we have the right mix of Republican, Democrats, and Independents right now? Because I don't see Peter Stoutberg here, but Mr. Caraway's recused himself.
2, 1, and 2.
Okay. So, okay, as it relates to the case, I'm only going to argue the first one, which is 2021G-018, because I want to have these. So, just for background on why I think there should be a preliminary hearing on this matter, is the things that Mr. Bry has not mentioned. First off, what I sent to him and to Phil Richter, the 171-page filing, was records of the commission. And what was the main part of that? Okay, on September 23rd, 2021, there was a motion hearing in the prior Freeman case about whether mail drops and things like that, political mailers, could be considered as part of that case or needed to be a separate case. In that September 23rd motion hearing, he argued it needed to be a separate case. He argued that it needed to be a separate case. That the only thing that could be considered in the prior case was the media expenses, which were TV and TV placement, TV advertising, that kind of stuff. Because that's what the evidence was in my affidavits. I had invoices that were for media stuff. There weren't any invoices or information specifically on mailers. Mailers, although I knew about mailers, a lot of the discovery revealed a lot of mailers and a lot of activity around mailers. So back on September 23rd, 2021, there was a hearing. It's probably about 60, 70 pages of transcript on this matter. It ended up, the funny part is, his motion then was that the case could not include stuff other than media stuff. Ultimately, if you go read that, and that's what I sent to Phil Ricker, I encourage you guys to go back and read those minutes. Not those minutes, that transcript, is that what happened was, it tied, the motion failed on a tie vote 3-3, but the determinative difference was basically 0. Some of you were here, because it was, if it, under the normal, what was being said was the rules, I had to stick to only the media expenditures, and so kind of if it passed or failed, it didn't matter, but it failed on a 3-3 tie. So what happened was this, well, part of that discussion, if you go read that transcript, was also that I should, if I try to amend the complaint to include print and mail, that would cause a reset of everything and we'd have to start everything from scratch. And that one of the alternative proposals to me, if you go read that transcript, was to file another complaint. And that complaint could, at the direction of the executive director per OAC 3517-107, could then be consolidated. So that then it would become one case, like the Stewart case. We'll have a Stewart case where you guys consolidated two things, got consolidated. I filed a second complaint on October 12th, 2021, that was specific to print and mail activities of the Freeman campaign. Remembering, he's the one that argued that that's the way I had to do it. The executive director never held a preliminary hearing on that case, which is the one before us right now. He never had a hearing and therefore it was never consolidated. So it's kind of like saying you robbed the Norms from here and you robbed the Norms from here. Well, we have to have that be one case. No, they argue that it should be a separate case. So I think, you know, and if you go back and look at the history, because I went through and looked at all the dates of what things happened at different points in time, is that the print and mail part of the Freeman campaign is a separate and distinct set of activities. Those of you here might remember that basically the activities that were media was about $180,000 of unreported in-kind contributions. There was about another $100,000 to $120,000 that was unaccounted for, that because there were some invoices that came out that had higher numbers during discovery. And that's, I think, the print part, the print and mailing part. So my view is that that case should be, that we should have a preliminary hearing on it versus continuing. And I think then it should be held over for a full hearing, okay? And then once the facts are determined, the biggest thing that would come into play for the commission is how does the prior fine relate to a finding of violation in that case? Because then you're going to get into the issues of, well, what happens if they've already been fined for having faulty statements, and now we found another issue that involves the same statements? Do they get fined again on those same statements or not? The one other factor that comes into play on this case, in particular, more than the other one, is this whole notion of, that's going to come up and needs to get addressed by this commission, of what happens if somebody terminates their committee. And I just want to point out that I have repeatedly requested that there be an advisory opinion of the Ohio Elections Commission on what's the impact on jurisdiction of the Ohio Election Commission if somebody terminates their committee, okay? I've eventually put it in an actual advisory opinion request consistent with OAC Rule 3517-102. I hear nothing about it. I don't have the talk line with Director Ricker. So that's another important thing on this case, is the what's happened. Now the good news is that Alan Freeman has reestablished his committee that he closed down. By the way, he closed down his committee in between when the commission had its public deliberation on what its finding was going to be in the prior case, and then voted on what Mr. Ricker had been instructed to draft. That's when Alan Freeman, in the days intervening, he shut down his committee, and then he tried to have a motion saying that the OEC couldn't find against him because they had no jurisdiction because they shut down the committee. So that's what happened within that time frame. So on this case, on this particular case, it is from, I have to go back and look, but 2021. I get to go back and look at when was it actually filed. It's now 2023. And as it was scheduled for preliminary hearing today, I believe that it should be held over for a full hearing, and then we could pause on doing the full hearing until these other matters are resolved. But let's get the preliminary hearing out of the way so that we can at least have this moving forward. And I haven't made a dangerous trip in the rain from Cincinnati to Columbus. So thank you.
If I may respond to a couple of points Mr. Hicks made in his presentation. First of all, he made a slur against Phil Richter. He didn't walk and hand me the agenda. I walked up to him, asked him about the agenda, just like Mr. Hicks did later, and he gave it to me as he would to anybody who comes up and asks me. Secondly, Mr. Hicks spends a great deal of time talking about hearings and proceedings and evidence in the case that is on appeal. He said, let's take a look at this transcript of September 23, 2021, and there was regards that we had moved, Mr. Alan Freeman had moved, that the hearing be limited to the matters that were pled in the pleadings. And that failed on a 3-3 vote. There was a suggestion by at least one of the commissioners that Mr. Hicks either amend his complaint or file a new complaint and seek to have it consolidated with the original. Now, he did file another one after the hearings in the case that already happened, or begun to happen, but he made no motion to consolidate. And the argument that I made at the time is, you need to give the respondent an opportunity to have another preliminary review another opportunity to move to dismiss new charges that are in it. Now, Mr. Hicks says it doesn't matter because you were limited to what was pled anyways, but that's not what the decision in the first case did. The decision in the first case relied upon statutes, subsections of statutes that were never cited, and facts that were never alleged to be violations.
I object to this. This is hearsay on that case, that he's making representations of what your decision was.
I would ask that Mr. Hicks not interrupt me while I'm speaking.
Well, I object
I
to
would ask that Mr. Hicks
characterizing
not
the board.
interrupt while I'm
You're not in a
speaking.
position, they can read their own decisions from the past.
Then I'm talking about the decisions you have made from the past, and I'm talking to the commission. I'm not talking to Mr. Hicks. And I showed him the courtesy of not interrupting, except to affirm a procedural point.
But I object to you telling the commission that they
And
did certain things that they didn't do.
Okay,
Madam-
that's really noted.
Madam Chairman, I personally object to many of the false statements that Mr. Hicks has made. I did not interrupt him to correct them at the time. I'm doing that now. Early summary. And one of the statements he made, if I recall correctly, you were all here just a few minutes ago, was that the commission was limited to what he pled in his complaint. Well, even though our motions are so limited, failed in three times. That's not how motions work. My motion failed, and it is not what the commission actually did. And in fact, this commission, through its counsel, does not deny in the appeal of the original case that it went beyond the facts alleged to be violation in this plea.
I object. He's
And
making
he did
statements
not-
about this commission that are not in evidence here.
I ask Madam Chairman, please instruct Mr. Hicks to keep quiet while I'm speaking.
I think
Rather
I
than
can
try to make
object.
it more difficult for me to speak.
Duly noted. Your objection is noted.
As I was saying before I was so rudely interrupted, this commission has argued through its counsel in the Court of Appeals that it does not deny, it never denied, this commission has never denied in the appeals that it found violations that weren't in the pleadings that Mr. Hicks had found. It never denied that it found violations of the subsections of statutes that were never cited in the pleadings. What it alleges in the appeal is that it has the right to go beyond and find violations of facts and of statutes that were never pled.
What does this have to do? I object to this.
And what this has to do is with the motion to continue is that this is a disputed fact. You can hear Mr. Hicks arguing, he doesn't want you to hear about it. He doesn't want you to know that the Court of Appeals and you have been released. I apologize, I should refer to that.
Yes,
But nonetheless,
thank you.
the three case, he also said, well, since he filed a complaint, I think in October, I'm not sure, I have to check the dates of when the original evidentiary hearings, but there are other motions and so forth going on. But he never filed a motion to consolidate the new complaint with Wilbur. You know, he just apparently thinks that this ought to automatically happen. He never asked for that. He also never sought to amend. He could have filed a motion for leave to amend his complaint. It would, in my view, have required an additional preliminary review. If you have new facts in the statute, we should have an opportunity to defend against them. But he never sought to do that. And he said, what happens? He's telling this commission there's a big issue in front of you while you are hearing these new cases. Because what happens if somebody terminates their committee? That's an issue that's on appeal right now. You know, because one of the arguments we made, and the commission has disagreed with it through its counsel, is that you can't have a fine against a committee that doesn't exist anymore. And we have, that's been fully briefed, it's been argued. That is a case, probably the reason, I don't know what the reason is, but I suspect the reason for this commission not to issue an advisory opinion on something that the Court of Appeals already has in front of it in a live case involving this commission is because whatever this commission says is probably going to be trumped if the Court of Appeals addresses the same issue that's been presented to it. One more reason why we ought to continue this case until those appeals are resolved. And lastly, he makes an assertion that the same committee has been reestablished. That's since, well, he may not know the difference because it's not a law, but in fact, it's not the same
I
committee.
object to the end.
I was trying to be courteous, not pejorative. You know, you know, the reality is that that's not the case. What has happened was Mr. Freeman had a state committee which has the limitations that committees for statewide offices and committees for state legislature have. It was zeroed out. There was not a transfer fund or assets. It went out of existence. And sometime later, because everything's been pending for a while, he created a new committee that starts from ground zero for his township trustee race, which is not a state committee. It doesn't have the same restrictions. It's not a state campaign committee. It's a local campaign committee that's filed not with Secretary of State, but with, I believe, Fremont County, with memory serves. In other words, there's a lot of stuff here that gets complicated, it gets confusing, it gets voluminous, witnessed the 171-page filing this morning. But if these things are continued to let the Court of Appeals and possibly, but not certainly, the High Supreme Court sort out the original case, this commission will be in a much better position to narrow its focus and decide whether there is or is not merit to the new case and the cases Mr. Hicks has brought.
Can I respond quickly? So just quickly. First off, Mr. Freeman's new committee set up, he checked off both new and update on the form. And it's then marked as he was just changing the treasurer information. So this could be later, you know, but when he says he set up a new one from scratch. What I wanted to do real quick, just to respond to him and then be done, is I'm going to actually, in the 171-page filing, was mostly me sending a copy of transcript of a prior hearing, telling the director that I might quote from this transcript of your prior hearing. So Ms. Cunningham, former commissioner, says, it's on page 65, if someone's looked it up. If we grant the motion, this is his motion, to limit, he was trying to limit that we couldn't deal with print media stuff as part of the prior case. It had to be separate, okay? If we grant that motion, you're limited, she's talking to me, you're limited to the items specified in the complaint in 6 invoices. Mr. Hicks, okay, I think you should deny that motion. Ms. Cunningham, okay, if we deny the motion, Commissioner Norman, who's also another attorney, is saying you will be limited to what is in the complaint. Mr. Hicks, so you are just telling me us the same thing, deny, and then I get, Ms. Cunningham, that's the law. That's what he thinks the law says. So that motion back then, I would encourage you. I sent him the transcript to go read the transcript of the hearing about this, of the motion hearing about that matter back then, because I was told that no matter how that motion came out, I was limited, and my options were to do a amended, which would cause a complete restart of the whole process, or file another complaint. So I filed another complaint, and then he acts like I was not diligent after I did all that, because I didn't then do a motion. Well, I want to remind everybody that that's not my job. Per OAC 35171-07, quote, B, quote, staff attorney to the commission may, in the sole discretion of the staff attorney, not the commission, in the sole discretion of the staff attorney, consolidate cases involving substantially similar parties and issues. That wasn't a matter to be heard before the commission, because the rules say that's his decision to do that. The staff attorney solely makes that decision. So again, on this matter, on this first case, I think we should, you know what, on the first one, I want to argue the second one separately because it's a very different case. But on the first one, I want to say after all this discussion, I think it would probably be best, not that I agree with it, to just continue the matter on this first case. Thank you.
So moved. All right, we have a motion on the floor that's been duly seconded. All in favor, signify by saying
May I
aye.
ask a question? For the executive director. I guess I would like to understand if the general viewpoint was that we should wait until the court process ends. Why did it come up on the calendar at all to require this whole continuance thing.
Mr. Hicks, made a, shoot, I can't remember all of a sudden,
Mandamus?
a mandamus action against the commission to move certain matters forward.
Okay,
And there are two of them, so I'm moving them forward based on that, so that we can enact others.
got it. So because the mandamus moved it forward, and then you brought up that point. Okay, that's all I wanted to know. Thank you.
Yeah, and in anticipation, same for the second.
Got it, got it.
Madam Chair, since I had motioned the continuance, is there also any information on when those appeals are being heard as of yet? Because
Not-
we can't set this for a date.
Not that I'm aware, I have not heard anything.
The Court of Appeals case has been fully briefed, it has been argued, and is waiting for decision.
Could we assign this to be heard no later than 2 meetings post that hearing or something along those lines without setting a date certain? So that it's just moving forward appropriately? Mr. Bell?
I would say go ahead, because I think I know what you're gonna say, go ahead.
If the Court of Appeals decides, it's possible that one side or the other will seek review by the Ohio Supreme Court. So at least from movement's point of view, it might be preferable to do a couple weeks after the appeals are fully resolved. For a couple of
I mean, I would phrase it in simple terms. I'm sure if the decision comes against Mr. Bryce, I could be wrong, but if the decision comes against Mr. Bryce, client, he would appeal, and if the decision is against the commission's interest, I'm sure I would suggest that the Attorney General's office appeal on our behalf. So therefore, you're down the line then to the Supreme Court decision. But then after that, that presumably is the end of it, is this is an Ohio issue, and so therefore that decision would presumably be final, and we could presumably be free to go forward. And I would certainly like to go forward as quickly as possible, yes.
Okay, then I would say I'm fine with my original motion.
Okay. We have a motion on the floor that has been duly seconded. All in favor, signify by saying aye.
Aye.
Pose same sign. Motion carried with a vote of 5-0. So that case is continued. The next case is 2022G-014. Mr. Ryan.
I pretty much presented the argument. The only two things that I would discuss are, Mr. Hicks has cited an updated treasurer. My understanding is that Mr. Freeman originally designated himself as the treasurer of this new township trustee committee and later updated it to someone else. And I suspect that we may be looking at the second designation treasurer rather than the first one. And secondly, again, I don't think it's relevant, but the comments that a couple of commissioners made at the hearing, they were on the losing side of the 3-3 vote. And obviously, what the commission did in the original case is a matter of record, not that you need to sort all that stuff out there.
Okay, just to clean up some stuff, he said that the first hearing in the prior case was on October 7th. It became clear to me in that hearing that I was not going to be allowed to reference the print and mail materials. And as such, that's when I filed on October 12th another complaint because of the actual, and the people that were on the losing side of that were people that were saying that it didn't matter which way the motion was resolved, so obviously they were going to vote on the losing side because they didn't care. Okay, on this particular case, I just also want to clarify that what he said about filings with the Claremont County for his treasurer, that's not true. I have all the forms that Mr. Freeman has ever filed as designation of treasurer forms, and the last one prior to January 11, 2023 was on November 26, 2019. So that was prior to his running for state rep. So there's been no intervening changing of treasurers. I just want to clean up factually and accurate information. On this particular case, it is not the same as the other one. So let me explain why it's different. This case doesn't involve the web media expenses print. It involves specifically the treasurer, Susan Jones, filing an annual campaign finance report, which she did on December 13th just by way of timeline, the commission on the prior matter, the commission had its public deliberations on December 7th. It was going to meet to approve what they'd instructed Mr. Richter to draft on the 16th. On the 13th, the treasurer of the Freeman campaign filed a annual financial report, which, by the way, those of you that know when these filings are due, that's very early. They filed an annual report before the year was over, and included with that a termination. And then he argued in a motion that because the committee was terminated, there was no jurisdiction of the Ohio Election Commission, and that therefore you could not find against them on the 16th, which, by the way, is it's not, to my view, good. Okay, so that's those events. This case, the case that we're talking about right now, 2022G-014, is specifically about the treasurer filing an annual report, or whatever it was, an annual report, when they knew, knowingly, that there had been things that were unreported and doing nothing on the report to report anything or to correct it or to wait for the determination of the commission to file a correct annual report. Let me say, and I'm sure Mr. Bry will object, it was effectively a stunt to file that annual report with a termination check on it, to get which, by the way, the gentleman who then terminated the committee was Brian Katz, okay? So terminated the committee, and then he came in here and argued that they couldn't have a finding against the committee because it had been terminated. Unfortunately, right, wrong, or indifferent, at the time of the hearing on December 16th, you can go read that transcript, the committee for Alan Freeman still showed as active on the Secretary of State's site. If you go look at it now, it'll say it was terminated on December 13th, but at that point in time, there was no filing reflected on that site. Mr. Bright had to have a motion that he filed on December 15th. So this case is not the same as the other one. This case has to do specifically with the treasurer, Susan Jones, who was not a named party in the prior one, according to Mr. Bry. I think she was, but according to his argument, she wasn't. So filing that annual report and termination while knowing that there was a pending finding that there were unreported expenses. And that's what this case is about. It's not about whether it's media expenses, it's just about the fact that an annual report, remember, there's different reports. Annual reports, semi-annual, and if you guys haven't studied it, just for quick background, if you look at those code sections, the differences between like an A and B section and C, it's not that it's different matters, it's like A relates to the semi-annual report, B relates to the pre, so there's different code sections. In the same statute, there's A, B, C, D, and E, which points to whether it's pre-primary, post-primary, semi-annual, or annual. And one of their arguments is that if the commission finds during a hearing that, well, this expense was a problem, but it should have been on the post-primary versus pre-primary, then that would mean the whole case was void because they had not been informed that they were being held to account for a post-primary versus a pre-primary report. And that's something that should be part of, an advisory opinion as well, in my view. But in this case, I just want to point out that it's a very different matter because it has only to do with the filing of that annual report by the treasurer while knowing that there was an imminent ruling. By the way, the treasurer had sat through all of the hearings in that prior matter. So this one, I think, should have preliminary review and not be continued because it's substantially different and it wouldn't be impacted by the prior case in my view.
A couple things, primarily related to our motion to continue, which is the motion number 4. The motion to continue also should be granted because the whole notion about the termination of the committee is a matter that's before the Court of Appeals right now. It's been briefed by both sides. It's been argued whether that termination was effective. And Mr. Hicks has made the argument that the whole legal ramifications of the motion to continue, of the termination, or rather the termination of the committee, is something that is involved with this third case, or the second case that's on the agenda today, but it's also something that's in front of the Court of Appeals today, as we said. And it is disputed. He says, well, we must be wrong on the merits, because the website wasn't updated to reflect the termination committee as of December 13, 2021 until sometime later. I gotta tell you, you can probably find me listed as a lawyer with firms that have been doing that for years. Websites are not always updated instantaneously. Even the website of the Ohio Elections Commission is pretty good, but it's not instantaneous when it updates things. He also, this isn't really relevant to the motion, but it's a point of privilege. He makes several accusations of being stunned, of being dishonest, and that and everything. The reality is, the commission had not voted to impose a fine orally until the 15th, which was after the
16th.
I believe it's the 15th. Well, I relied upon what you said in here. And here you said that, oh, you're right, it is 16th. He's correct, I'm incorrect. It is the 16th of December when the commission met and made the vote to impose, whatever penalty imposed, which is 3 days after the termination by our count. Obviously, the commission wasn't persuaded by that and went forward and did whatever it did. Having said that, when the committee was terminated, there was no vote to impose a fine. There wasn't any action, but there was no liability. And I spoke with Brian Katz. He said, is this something, can we terminate the committee? And he said, yeah, you can, which is why we did, because they'd run out of money. And there was no particular reason to keep the committee in existence for somebody who's not running for statewide office again, and that didn't have any money. And there were certain, yes, there were certain advantages to doing it. You can't get blood from a turnip, and the best way to show that you're dealing with a turnip is to dissolve it, which is what we did. But the main thing is, he's saying this is different because this deals with a bunch of issues relating to the termination committee. The Ohio Franklin County Court of Appeals is also dealing with issues related to the termination committee. This is one more reason, in addition to all the other ones we've gone through ad nauseam, that this matter, like the other one, should be continued until the appeals are resolved.
I have a 10-second comment. So I just want to point out, I have nothing else to say other than, again, he said Brian Katz was the person that told him they could do this stunt. And again, so Mr. Katz's name comes up again, is having these conversations on the side with other people. Thank you. And since he's watching his watch, I wanted to go get it.
Thank you. Commissioners, any questions on Mr. Breyer, Mr. Hicks?
So I do, I guess, and probably Mr. Hicks. So this case 19 obviously is against Ms. Jones, correct?
I
Or
think
is it
it's,
also, does this also have culpability for Mr. Freeman?
I think it has both, frankly, because it's the committee also, but, and I think you're mixing the numbers up. So this, the one that's about the filing is 2022G-014.
Correct.
Yeah, you said 19.
I'm sorry, I'm looking at your evidence probable
Yeah.
cause here we had during the case, but okay, it was not my.
But the actor
I
in
got
this
you.
event
She
was
She
specifically
sat
Susan
through, I knew
Jones,
that's my.
the treasurer, not Alan Freeman.
So you're suggesting that this would have culpability for Mr. Freeman?
I'm suggesting that the actions were on the part of Susan Jones,
I did
and that ultimately the commission would determine what was the violation and who was culpable for it.
Okay.
Any questions from commissioners?
I guess I have one for Phil. So, Mr. Victor, so if, on this case on 14, if we grant a continuance, does this in any way put Mr. Hicks' case, I guess, in jeopardy with respect to staying active and being timely?
I believe because the request is coming from a respondent, whose, let's say, rights are at issue here, and that's the one who's requesting that the matter be continued to a later date for their benefit, I would answer that no.
Will you clarify that? I'm sorry. So we would not put Mr. Hicks' case
Okay.
together?
Correct.
Just want to make sure I.
Yeah, I'm asking if it continued, got it.
I mean, because it would be hard for Mr. Bride to then subsequently come in and say, you waited too long, when we're waiting so long based on his request for us to wait so long.
Right, and I was trying to wash that with the comments from the transcript saying that his case would be limited on appeal. That's, am I confusing this?
If I may address it, Mr. Hicks read through the transcript, I don't have it with me, but I was there, I skimmed through it last night, or this morning, didn't have it last night. The transcript were comments of two of the commissioners who voted to grant my motion to limit it. The motion was not successful, it failed on a 3-3 vote, which is a fail. And the evidence was not limited, and the decision was not limited. And so whatever it might have been, that's not what happened. And that is, as I said before, a matter that is in dispute and argued in the ongoing litigation on the original matter. There's a lot of stuff in the original matter, and this case, or the cases, can get fairly confusing. I'm not suggesting that waiting will get rid of all the confusion, but I think it will get rid of some.
I just want to correct the records, so of the two commissioners whose names were mentioned, Ms. Cunningham voted no on the motion,
Okay.
and Mr. Norman voted yes. So the two people who were, that's because they were two of the people arguing that it didn't make a difference, and actually then one of them voted yes and one of them voted no, which is on page 77 of that transcript.
I defer to his recollection, obviously, he's read through it, and I have. I thought they both voted the same way, but in any event, that's not what happened. And again, Ms. Cunningham said, Mr. Norman is telling you this is how it works. May not have been for you. I don't know.
So, Mr. Bryan, your opinion, by us granting a continuance, does that limit Mr. Hicks' case in any way?
Well, if we're doing it, no, the continuance won't limit this case. I think some other things will limit this case, but we haven't gotten to the merits of a preliminary review yet. So, yes, I mean, if we.
I'm just talking about the continuance.
No,
don't want to
I
change
think
the
Phil's right. If we ask for continuance and you grant our continuance, you can't have us come back and say, well, you have to dismiss it now because the motion that we made to continue was granted. In other words,
Okay.
I can't do that, and I think that such an argument would be unsuccessful.
I feel differently because, and that's why I oppose continuing these cases, because when these things stretch out forever, and I don't want to sound morose, but probably a lot of people in this room know that the husband of Gene Schmidt, the treasurer Peter Schmidt, who was a witness in that other case, passed away. So if cases take forever and you actually get to the point where witnesses are literally not available, then that affects the ability of me to put forward a case. So I think there's a balancing act that takes place. I think it's correct is that he could not come back and argue that he, was past the statute of limitations when he's the one who requested. But I think there's an interest in there being speedy justice. And when we keep stretching things out for years, literally, you do run the risk to get witnesses who physically can never testify again.
I've been doing litigation for some time, and every court has a duty to administer justice with deliberate speed. But they define it how they define it, and there's not a lot we can do about it. I don't think if the legal system, the judicial system says this is fast enough, that we're really in much of a position to say they're wrong.
Any other questions? Any questions for Clayton Ursula or Mr. Ripley? Hearing none, do we have a motion? We all know what Mr. Richter's recommendation is.
I'll move the motion to continue.
Second.
We have a motion on the floor that's